Cool. So hi everyone, welcome to the final part of our Making Marks KW digital programme in partnership with the British Council. My name is Becky and I'm the Events and Communications Officer at the Arab British Centre. I'm joined by my colleague Amani Hassan, who is the Programme Director. She's just giving you a wave. The Arab British Centre, in case you don't know, is a charity based in London that promotes understanding of the Arab world in the UK. We do loads of different things, loads of projects. We have a film festival, we have different residencies with artists based in the UK and the region, and I really recommend that you check out all of the things that we're up to at the moment on our website, which you will have found because you signed up to this workshop. Just quickly, the Making Marks programme started in 2019 with a exchange programme between the UK and Kuwait, with 4 artists from each of the respective countries having a kind of visit to the opposite country, and then they were all commissioned to make work. They were supposed to have an exhibition in Kuwait earlier in the year, but unfortunately that got cancelled due to the lockdown. So thankfully, the British Council allowed us to do a digital programme in its place, celebrating their work and also providing new opportunities for early career artists online. So yeah, thank you to the British Council for partnering with us on this. So this workshop today is called, oh my God, I've lost my trail of thought. Digital art law, what you need to know when posting your work online. Sorry, you can tell that this is the final workshop out of a programme of many different things. And we're absolutely delighted to be joined by Fionnuala Rogers, who is going to be leading this workshop. So Fionnuala is an art and cultural heritage lawyer who founded Canvas Art Law in 2017. She has extensive experience working in the UK and the Gulf regions and is extremely knowledgeable about all things to do with art law. Yeah, she's also, really excitingly, the latest addition to the Arab British Centre trustees. So we're really excited to be embarking on a new journey with Fionnuala as part of the trustee team as well. So yeah, I'll hand over to Fionnuala in a minute. So this is a workshop which is aimed to give you some knowledge about the digital art law in the UK and the Gulf. It's not official legal advice, it's more of a opportunity for you to learn a bit and then pursue your own research in the future around these things. So Fionnuala, thank you very much. Oh, and sorry, I will just say, if you could please wait until the end for questions. We're going to have a dedicated discussion and time for questions at the end. Feel free to send them into the chat bar while Fionnuala's talking, but we'll go back to them. And Priyanjali said the presentation slides be shared. We'll be recording this workshop, and so the slides will be available as part of the recording as well. Yeah, Fionnuala, over to you. Thank you.
Thank you very much. And nice to see so many people. That's wonderful. So I will just... Okay. Okay. Brilliant. So as Becky said, I'm an art lawyer. I've been working in Europe and the Gulf since about 2012, exclusively in art and cultural heritage matters. But social media and art online is just so fast paced, and it's been changing so much over the last few years, but then, you know, particularly in the last few months, of course, with lockdowns around the world. So we thought it would be really topical to go through some of the issues around sort of posting your artwork online and selling your artwork online. So what we're going to cover today, we're going to go through a quick overview about your IP rights when you sign up to social media. Then we're going to have a very, very whistle-stop refresher of kind of copyright from the UK and some GCC countries as well. But what I'm keen to do is not just focus on copyright, because I think most of the artists on the call will probably have some understanding. So I really want to focus on the online element. Then we'll talk a bit about selling your works online, either via your website or social media. And then we'll go through some practical tips about how to promote and protect yourself online and strike a balance between the two. And I'm going to leave about 20-25 minutes for questions, because I think this is such an interesting topic to artists around the world, that it'd be great to get some experiences and discussion going. So we'll go through the presentation, but we will leave plenty of time for your questions in the chat. So we're going to kick off with understanding, I'm going to call it your contract with the social media platforms. And when I say that, most people turn around to me and they say, hang on, what contract? I didn't sign anything. You know, they have no idea what I'm talking about. But of course, you know, when you're on your phone and you're creating your profile and you tick that box that said, you know, I agree to all the terms, all the conditions, sign my life away, and very few people actually read them. What I think is really important for artists is to understand what it says in there about IP rights. Now, you can't really change it because you're not going to be able to kind of call up Twitter and say, I want to negotiate. It's very unlikely you're going to get a response. But I think it's really important to understand what you've signed. So let's just have a look. So these are the standard terms from Instagram, Facebook, and Twitter about the license that you grant when you share your content online. Now they're all very, very similar, and people tend to read them, and you know they sort of either don't know what it means or they just think it's absolutely fine. And I think the important thing is just understanding these terms that you've agreed to, and then sort of deciding what you're going to post and how you might protect yourself. So what these terms actually do is they say that when you post your content online, you still own the copyright and the IP rights. That doesn't change. But what you are doing is you're granting a license to the platform. And if you look at some of the examples, you're granting a license for them to distribute, modify, run, copy, publicly perform, display, translate, create derivative works of your content. So you're actually saying to the platform, you can do whatever you like with the artworks that I post on your platform, and you don't have to pay me any compensation, and you don't have to ask my permission. So most of the time when I flag this to artists, they start deleting their account immediately or pulling down all their posts, which I think is a normal reaction. And I think whilst we're going to talk about what this actually means, I think the thing to remember is that social media companies, they need users. They do not want to upset their users. And we haven't seen cases, you know, where Instagram has sort of taken a user's artwork and commercialized it and put it in a, you know, an advert, that kind of thing. So whilst they have these wide rights, in reality, if they started exercising them to this extent, they would very quickly lose all of their users. So whereas it's good to understand them and be aware, I wouldn't worry too much that Instagram's going to suddenly, you know, put all your works on t-shirts. So it's very important to see what the Ts&Cs actually say and have a look for those particular terms and just make sure you're comfortable that you understand them. As I said, they're not negotiable, so you're not going to be able to do anything about it. It's really accept it or don't use the platform or don't post your work. Now, the platforms can change their Ts&Cs at any time, but if there's a significant update, you usually will get an email, a notification to say, you know, we've changed our standard terms, and they tend to tell you in the email what the changes are, and they give you the right to actually pull off the platform before the changes come in. So if you get those emails, I know we all delete them without reading them, just have a look, because if you're quite concerned about the IP terms, just have a look for those kind of buzzwords about copyright, licensing, you know, have a look and see if anything's changed when you get those emails. And be aware that the terms and conditions are governed by different legislation than your country. So just because you're in one place, it doesn't mean that your contract with Instagram or Twitter is governed by that law. A lot of the social media platforms are based in Silicon Valley. Some of them are governed by Irish law, those kind of things. So, you know, even though you might sort of look at it from a legal perspective, it's not necessarily the same law that you're used to. So what it means is you still own the copyright. You're not giving away your copyright, you're just granting a license. So the main risk you as an artist is that if you have granted a license, say to a gallery or to a commercial brand, that they have exclusive rights to use an artwork, if you then post it on Instagram, you might actually be breaking that agreement with another party. So if you've said to I don't know, a fashion brand, that you've granted them an exclusive license to use your artwork, if you then post it on Instagram, you've granted a license to somebody else and you're in breach. So you need to be really careful, and just before you post things, just consider, you know, am I actually breaking any agreements with anybody else? So that's always something to be aware of. And if you've posted something on Instagram and then you then sign up with a gallery, or you want to grant a license to somebody else, just tell them, just say, I'll give you an exclusive license, that's fine, because it could be quite lucrative if you're getting paid, but just say, you know, just so you know, I did post this on social media previously and they have licensing terms. So that's pretty understandable. Most brands won't be concerned about that, but you should be aware of the sort of legal implications of posting on social media. So it's also quite good to understand the use by other users and what you can do and what you can't do. Now, some social media platforms actually say in their terms, other users can reshare your posts, they can reshare your content. Usually they say, you know, you have to credit the author, and some don't allow sharing, you know, without the author's permission. So it really depends what the terms say. So if you're worried that someone has reshared something and they haven't credited you, the best thing to do is to have a quick look at the terms, and then you can sort of push that on them and say, you know, you're in breach of the platform terms, I'm going to contact Twitter or Instagram and report you. That usually works, you know, most of the time, and you don't have to go to the lawyers. So your copyright, this is copyright 101, your rights are to exploit the work, to reproduce it, to publish it, and to create derivative works. These are pretty similar throughout the world. They're very, very kind of standard basic copyrights that you have as the artist. So what it means is if another user publishes the work, so they post it on their profile, even if they credit you, if they're not allowed to do that by the terms of the platform, they're infringing your copyright, and you can ask them to take it down. So I just want to have a quick look at what you can actually do, because this is the biggest complaint that we get from artists, saying other users are sort of reposting content, they're passing it off as their own, they're not crediting me. So these are some steps you can take, and we sort of go through the escalation process. So the easiest one, and usually the most effective, is the soft approach. So as I said, you contact the user, you tell them what they've done. If you're happy for them to share it, you know, you might decide that actually you just want a credit, but then you're happy for them to leave it up. Or if you're not keen, you might say, actually, you know, you're breaching my copyright, please take it down. If they ignore you after a couple of attempts, I always think it's worth doing it publicly and sort of, you know, be polite, say, thank you so much for sharing my work, I'm glad you like it, please credit me. And the public pressure usually does get a reaction, because then they can't pass it off as their own. If you're still getting no joy, you can seek assistance from the platform. Now, the good thing about social media platforms is they make it really easy for you to do this. So they all have like an online complaints form that you fill in, you copy the post, you send them something about when you first posted it, that it's your original work, and it is actually really straightforward to do. They then take a few days to have a look at it, and they will take the post down. And if a user keeps doing this, they will eventually remove the user from the platform. So I've done it a few times for artists, and it is really straightforward. If they don't do anything or they don't agree with you, Then for smaller platforms, you can actually contact the host as well. It's a bit more complicated, but you're actually threatening to go to the software provider who sort of hosts the platform. But that is another step up. Again, really straightforward, and they all have online forms to fill in. So it's always worth telling a user, this is what you're going to do. If you block the user to stop them copying, that's fine, but then you don't know whether they're taking it down or not, or what they're using it for. So I tend to sort of suggest avoiding that so you can keep an eye on them. And then later there's some tips about how, if you've blocked someone, you can still check use of your images that we'll go through. If none of this is working and you're really bothered by it, and it really is sort of bad faith that's going on, you can go down the legal route if you've not been able to resolve it. Now, the issues with this are because you might be in London, the software provider might be in Silicon Valley, and the person infringing might be in New York. It will cost you quite a lot of money speaking to lawyers just to find out which law applies to the situation. So you might actually spend your legal budget, if you have one, just on finding out what the law actually is, which is not a great situation to be in. IP infringement claims, they are really expensive, and the damages that you get are not what you would expect. So even though a lawyer shouldn't be saying don't go to a lawyer, I just want everyone to understand that it is quite a complex and expensive process. So as you'll see as we go through this, prevention is definitely better than cure. And if you don't want to have to go to a lawyer at the end of it, you know, all these kind of things and steps that you can go through really will save you in the long run. So now I just want to have a quick look at copyright from the UK and a couple of GCC country perspectives. And I'm only going to spend 5 minutes on this because I think everyone will be familiar with the copyright in their country. The key thing to understand here is, if you're not planning on going to a lawyer and running a big investigation, you've got to be aware of the copyright law in other countries, just because you need to understand what other users think is okay. And the reason that's important is because in the US, for example, we call them kind of copier-friendly laws. So there's a really wide discretion about what you can do. So taking somebody else's image and modifying it as your own, it's much easier to do that in the US. Whereas in many of the Gulf countries, they're much more artist-friendly. So they really do clamp down on people who are copying, and it's much harder to get away with. The UK is kind of a middle ground. We sort of have a bit more of a balance here, but you've got to think, well, what is the user thinking that they can actually do? So that's the important thing, because, you know, they might think it's absolutely fine to kind of slightly modify your work, whereas if you're in the Gulf, it's absolutely a no-no. So this is just a copyright refresher from the UK perspective. So it's the Copyright Designs and Patents Act. It protects original artistic works, regardless of the quality of the artwork. In the UK, the kind of protection lasts for 70 years after the artist's death. And you benefit automatically from copyright. So you don't have to register it. You don't have to put the copyright symbol on there. It's an automatic right. And then there are exceptions to protection. So you can copy someone's work for any of these reasons. And the most common ones are news reporting, fair dealing, study and research, or parody. They all turn on the facts. So it really does depend on how much is used, what the use is, and whether someone had access to the work. The UK also recognises moral rights, which is your right to be credited and to object if somebody distorts your work. Comparing that to the UAE, and we've chosen Saudi as well because it's an emerging art market destination. These are the comparisons. So what you'll see is it's quite similar, and they do tend to protect the same types of artwork as the UK. And something to be aware of is that there's an international convention which means that any country who's signed it agrees to protect your sort of home rights. So for example, if I've created an artwork and then I'm in the UAE, I can rely on my 70-year protection, even though in the UAE the law says 50, because they've signed the convention, which basically just says, you know, we will acknowledge your kind of home rights in copyright if they're higher than ours. So it's quite good for artists, because any country who's signed this international treaty kind of gets their like home benefits. So it means as long as you understand your copyright, you're fairly safe. Now, again, like I said before, it really is about the users and other people, because you won't all know every single copyright law across every country. So it's really about sort of protecting yourself, because someone might think it's fine, even though they don't know that you're protected by this sort of convention. And we don't expect people on social media to be legal experts. The difference in some countries that you need to be aware of is that if you want to go down the legal route, some countries require you to register your copyright. So the US is a classic example, and the UAE as well. It doesn't necessarily mean you're not protected. It's just if you actually want to sue somebody for breaching and infringing your copyright, you have to actually register it. So I've put the process for the UAE up here, just because I think we've got some artists from the UAE on the call. So it's always worth checking before you go down the route of actually trying to sue someone or threaten to sue someone. If it's not registered, you might struggle. So that's just a bit of copyright difference. And now what I want to go on to is selling works online and what you need to know. Now, just to say, this presentation is going to be recorded. There's a lot of information, and some of it does take a while to get your head round. So you'll have the slides, you can go back through things. If you have questions or you need more information when you go through the slides, you know, I'll give my contact details at the end, and, you know, happy for you to email and ask for further links if you want to do some further reading on what we've discussed. But I have put some templates in these slides as well. So when you're selling works online, again, it's this sort of knowing what your customer, country and law is. So you might say, well, I know what I'm doing here, I know what my obligations are, but if you're selling to somebody in France, then the law might favour them, and you might actually have to comply with legislation that you're not even aware of. So it's always worth having some terms on here. Okay, I think we've got some feedback, so if everyone can just make sure they're on mute, that would be great, because I was getting a bit of feedback there. So as we said earlier, I think social media in the past was used for marketing. So the auction houses were, you know, putting up their key works for sale on social media, but I don't think anyone was actually expecting to conclude sales via social media. So I think with coronavirus, this has really increased. We were expecting to see more sales completed on social media over the next few years, but certainly not at the rate that it's gone through. I mean, you know, everybody kind of selling their work online, auctioning artworks under the sort of help artist schemes that popped up in March and April. I mean, it was really exciting to see, but I think it probably happened a little bit quicker than anyone expected. And certainly when I looked on social media at artworks for sale, I didn't see anything about terms or, you know, protecting your sale. And I thought, wow, you're selling from New York to France and you're going to deliver, you know, somewhere else. And I thought, definitely some issues waiting to happen here. So I think some of the reasons that we heard why people were reluctant to buy online is that you can't actually inspect the work, and you don't know, you know, what sort of quality it is. You might be concerned about cybercrime, someone hacking into the payment methods, or just technical issues if you're bidding at auction. So these were all concerns that in surveys, they'd said buyers were reluctant to buy online for these reasons. But when lockdown hit, these all seemed to go out the window because there was just no other option. So I do think online sales, particularly via Instagram, are here to stay. So we need to get our house in order a little bit. So when you're thinking of selling, it is a contract between you and the buyer. And a contract, and this is an English law perspective, is an offer to sell. Somebody accepts and says, yeah, I want to buy that. Then there's intention to create legal relations, and then there's consideration. Now, these last two are really, really low thresholds. So the intention to create legal relations means you do actually mean to buy it. You do intend to pay money for this artwork. And I think if it's between two people that don't know each other, that's established. So a situation where you wouldn't have intention to create legal relations is if, you know, I said to my sister, oh, I'll give you £1 million if you make me a cup of tea. That's not going to be legal relations. But if I agreed to buy an artwork online and I don't know the artist, that's definitely past the threshold. Consideration just means money. Doesn't matter how much, it doesn't actually need to be currency. It can be any sort of value that you're offering in exchange. So in the UK, we recognise oral contracts. So if you've promised to do something, even if there's nothing in writing, it might still be valid. So on that basis, a contract of 280 characters on Twitter would also be valid, because that's actually easier to evidence than an oral contract. So when you're selling on social media, you need to be clear if you're actually forming a contract just in what you've put on there, or whether you're actually saying, I've got these works to sell, you know, please contact me and we'll discuss it. So I've put two examples on here now, which we can have a look at. So this is the first one. So this is an offer. So if you put the image of your artwork, the date, your name, and the price, if you just post that, and then a buyer says, oh, you know, brilliant, I love that, I'd really like to buy it. And if you respond, great, it's yours. That's a contract, because there's an offer, there's an acceptance, you don't know each other, so it's legal relations, and then there's a price. So that's your contract done. Now, if you're completely silent on everything else, there are still terms, you just might not know what they are. So we have implied terms in English law, and most countries have consumer laws, or they have laws of sale and purchase. So even if you don't agree all of this, if you're silent, it just goes to the default law. And the problem is, if you're in one country, your customer's in another, you don't really know what applies. So even though this is a quick and easy way of doing things, it could end up with some issues if you're not clear. This is a much safer way of doing things. So you can still complete sales over social media, but instead you're saying, you know, contact me if you're interested. And if you have a website, you might want to insert a link to some terms. If you don't, then you should just say, you know, we'll discuss the terms, like contact me privately. And it still works just as well. It just means that you might say, okay, I'm not going to post it to you until you've paid me, or you don't actually own it until you've paid me. Those really basic things, you can still conclude them in a message. It's absolutely fine. But this is just a safer way of doing things. And if the customer responds and says, oh yeah, I'd like to buy this, it gives you the chance to agree the terms before you're legally bound to sell. So just have a look at these examples next time if you're selling online, and just, you know, change the wording slightly to make sure you know what you're actually signing up to. If you have terms, and I do recommend that if you're going to be trading and selling online quite regularly, I do recommend having terms. These are some key points to include. So even if you don't have to have really lengthy contracts, you don't have to have reams of text. If you have a website, or you want to have a document that you can share just with the key points, that is immensely helpful, and it really will be sort of save you a headache in the long run. It doesn't actually, if you've got them and you've made them obvious, it doesn't matter if your customer reads them or not. As long as you've made an effort, that's usually sufficient. So the things to look at, you need to agree, well, when does the ownership actually transfer? Because if you say nothing, it might be that the default law tells you when ownership passes. So in some countries, ownership passes on payment, sometimes it passes on delivery, and sometimes, so in France, for example, it passes when you've agreed to sell, even if nobody's paid and it's not been delivered. So unless you say otherwise, you might be stuck with something you weren't intending. When we talk about risk, we basically mean, who's responsible if the artwork's damaged. So this is really important if you're shipping artworks, because in some countries it will be, risk doesn't pass to your client or your customer until they have the artwork. So if it's damaged during shipping, that's your responsibility. If you don't want to have that, you might say, okay, risk passes when you've paid and when I send the artwork. So that just means that the client is going to have to be responsible for insurance. Now, normally, it's better if you're shipping to say you'll be responsible. And if they're collecting, they're responsible. So it's always important to agree this so that you don't end up with an insurance claim or a bill for an artwork that got lost somewhere. Prices and costs as well. If you set out the price, you need to say whether you're charging VAT or not, or another tax that applies in your country. Because again, if you're silent, if you're selling it to a business, it assumes that VAT is extra. And if you're selling it to just a normal individual that we call a consumer, it assumes it's included. So again, when you're pricing your artworks, just make it really, really clear, or put something in some terms. Just including VAT or excluding VAT is perfectly sufficient. For your art-specific terms, now this applies regardless of which country you're in or where you're selling, because this could cause you problems in any situation. So if you're selling, just be clear that you've not committed to sell to somebody else on social media. And that's just, we did see a lot of artists saying, £500, first one to respond gets the work. And if they've missed a message, they've actually sold it to 2 people. We did see a few of these. So just be really clear, because it is a contract, you could actually end up being sued by somebody if you've sold it to somebody else. You need to make sure, if you're lucky enough to have a gallery or someone representing you, that you're not breaching your contract with them. Now, sometimes when you sign up with a gallery, they say, you can sell your own work if you want, that's fine, just don't contract with another gallery. But some galleries don't allow artists to do that. So even selling online, selling on Instagram, it could get you in hot water with your gallery. So you just need to make sure you know what the rules are and what you've agreed. Be aware of the platform rules. So when you sell on an auction platform, you're bound to sell to the highest bidder, even if there's only one bidder and you're selling something for 5% of what you wanted. You will be tied to that sale and you can't pull out of it. It's a bit like selling on eBay. So just be really clear, of your reserve price if you're going to do that. Then the big one is being clear on the description. So if it's an edition, the edition number in the series, what size is it? That's a big issue where, photographs really don't tell you. I can't remember if I told Amani this story, but I once worked for a client who'd bought a painting and it was being delivered in Qatar actually. And I had a very, very angry buyer phoning me at 6 in the morning. I just got out of the shower and there were shippers trying to wedge this painting through the door because it was actually like 5 meters high, and they hadn't read it, nobody had thought about it, and it just didn't occur to us that this work was actually enormous, and I've never forgotten it. So dimensions are so important because no one wants to be in that situation, especially in the blistering heat as well. So if it's a collaboration and it's not necessarily just your work, that's important to say. any issues of whether you sign your work or you have another like authentication method, specify it, because some buyers will say, hang on, you've sent me a work, it's not signed. So you need to say like whether it will be signed or not, and if that's not your normal practice, just make that clear. If it's an installation, of course, the instructions, and if it's a performance piece, again, instructions about sort of public performance, that kind of thing. So as much information as possible, and it really helps to put headings. So you say, you know, like dimensions, put what they are, so nobody is confused. And the reason that this is so important is, again, because the law implies everything for you if you don't say it. So again, and this is UK legislation, but it applies pretty much across Europe under consumer rights. So it's quite similar. And the reason it's important for people outside of the EU to be aware of is because if you're selling to someone in the EU, they have these rights. So even though they don't apply to you when you're selling in your country, if you're selling someone to a consumer, which is basically an individual, not a business, if you're selling to a consumer, they can rely on these rights, even though this law has like nothing to do with you. So these are things you do need to be aware of. So when we say satisfactory quality, and I must say this law was not written with artwork in mind, it was written for like washing machines. So when we're saying it's got to be a reasonable standard, it's got to work. Of course, that doesn't apply for an artwork. So the threshold is going to be really low, but it will be decided on like case by case. So if you've decided, and I did know an artist who did do perishable artwork, if you've decided to make an artwork out of cheese, which is a real story, you know, you need to make that clear that it probably won't last forever. So satisfactory quality, someone might think, you know, that they've got it for a long time. That's when they look at your description, advertising, you know, the price, those kind of things. Fit for purpose. Now this one, it really depends if you know what the purpose is, or if it's really obvious. So if you're selling an outdoor sculpture, and if you know where the buyer lives, you might think, well, it's got to withstand, you know, kind of weather. Whereas if you were selling a print that's typically indoor, that wouldn't be expected. So it's whatever they've told you about what it's for, or if it's obvious on what you've created. But again, it's a very low threshold for artwork. So you don't need to worry too much. And the way to save yourself from getting caught is just to have a really detailed description. And then we say it's got to be as described. So don't manipulate your images when you're advertising online and selling online. And if you want to be careful, you can just say, you know, color might differ, because of course everyone's got different pixels on their screens. You might want to have a disclaimer, you know, just to say that, you know, images might vary slightly, and you know, they can ask for more information, they can ask for further photos, but just be a bit careful there, because you could get complaints that it's not as described. If you're selling through a website, you have to sort of decide, are you going to have this like pay now function, or are you going to have a contact us? And that's again the sort of offer or invitation distinction. If you have a pay now option, then you must have terms on there, because the buyer needs to know what they're signing up to. So if tax is extra, it's got to be really obvious. If shipping is extra, it's got to be really obvious. You've got to have almost like, I call it an idiot-proof warning, that when you click pay now, it means they're actually going to have to buy it and pay money. So you do have to have quite a lot on your website if you go for this option. You know, you can get this sorted, you can have some terms, but it is a bit of more of a headache for you. A contact us is much better, because then they inquire about the work and you can actually discuss terms with them. The benefit of pay now is that it's quicker and you just have an automatic sale. So it's really up to you and how you want to sell your artworks, but that's just to be aware of. And then the final online sale shocker, which I think, again, this law was for washing machines and not for artworks. It's another EU piece of legislation, and it's the right to cancel. And this has been such a debate in the art world since it came in, because it just doesn't work for artworks, because they're unique. But basically, if you're buying at a distance, so you're buying on social media or online, by phone, by email, if you basically don't go into the premises to buy whatever you're buying, then you have a right to cancel. You have like a 14-day right to send it back. This doesn't apply to auctions, but that's the only exemption in the art world. And again, this is something where if you're outside of the EU, but you're selling in the EU, consumers can rely on this. So we have, galleries and artists in New York who just think this is crazy, because they said, well, I've sold like £1 million work, and 2 weeks later it could come back again. And that is the case. So what you have to do is you have to tell clients that they have this right to cancel and to return the work within 14 days. Now, not that many people know about it. So some artists and some galleries decide not to say anything and just hope that nobody notices. The problem is, if you do that, then they get up to 12 months to return it. So it's great if you know about it, because you could buy an artwork, have it on your wall for 12 months, and then be like, I'm not so sure I like it anymore, I'm going to send it back. So 2 weeks, is a much shorter time. So you should really think about that. Now, this only applies if you're selling as a trader. So if you just sell occasionally and it's not your business, then this won't apply to you. So if I sold something, to somebody on Facebook Marketplace or something, then that doesn't apply to me. But if you're an artist and you're selling as a business, and this is your profession, this will catch you. So you do need to be aware, and you do need to put it on your terms somewhere, and just be conscious that actually when you're selling artworks, you might get some come back again. I've put on here the effects of withdrawing or cancellation. Now, they can vary, but it basically means, you have to give a refund. Sometimes you will be required to collect the work, but that's only if you've agreed it in advance. Normally, the customer has to send it back and they pay for the cost. If it's been damaged, you can deduct the amount as long as you've made that clear to them. So it will depend case by case on what you've agreed with them. Now, again, it's just better to have this in some terms or on your website, so that everything is really clear cut, because these rules are quite like buyer friendly. So you have to give them details of the address, you have to tell them when they're going to get their payment back, you have to understand the payment method. It's the kind of thing, if you were sending something back to Amazon, you have to go through that whole process of where it goes back to, when you'll get your money, all of those things. And like I said, it wasn't really made for artists, it was definitely made for washing machines. Here is some example wording that I've just put up on the screen. So you can take a screenshot of this if it's helpful. This is the type of thing you would put in your terms, and then you could even put an example cancellation form to make sure that it's really easy for people to notify you that they've changed their mind. Now, we've put here the UK legislation, depends which country you're in. But again, for people who are in the Gulf looking at this, it's probably best just to have the right to cancellation, not specify the law, and just give a form that they can send it back to. Now, the final couple of minutes, because I think I've spent 45 minutes frightening everybody, which is the job of a lawyer, we thought we'd go through some things you can do to actually protect yourself online, because a lot of these are kind of risks and restrictions, but there's an awful lot you can do without having to speak to lawyers and just to protect yourself. So there's a balance to strike, because I think most people say, okay, I'm not using social media anymore, it's too risky, all my work's being copied. That's not the case, because of course the whole point is to market yourself and to share your work. So this is an example of kind of what you don't want. You don't want to go overboard, put disclaimers all over it, blur the image, you know, all these things at once are probably a bit overkill. But these are some tips of things you can do, and you don't need to use all of them, just one or two in a particular situation. So what you can do is you can use low resolution images on social media, because on social media, you can't disable the right-click copy function like you can on your website. So on your website, you can stop people copying, but on social media, it's not possible. So you might put low resolution images and then link to your website so they can see better, or you can say, contact me for high resolution if you're selling. This copyright line, the little C symbol, now it doesn't, you don't have to have that to get protection, and it doesn't actually mean a whole lot. It just puts somebody on notice that it's in copyright. Now, it's probably quite a good idea to have it, because most people around the world see that and they think, okay, that's copyrighted. But if you don't have that, okay, it's fair game. So even though there's no legal basis, it's probably a good idea just to put that there. Even if you just put it on the image or below the image, it does just alert people that it's not kind of a free-for-all to use it. You can have disclaimers on your website or in your profile, but again, don't go overboard, because you don't want to be seen as being like sort of, you know, paranoid. If you have blocked people on social media, or if you're concerned that your images are being used, you can use software like Google Image Search to try and find your images and see where they're being used. I mean, that's quite a good tool, especially if you've blocked somebody. You can add watermarks to the images as well. Now, again, it doesn't stop somebody copying them, but it does mean that they won't be used commercially. Like, they're not going to be used in an advert if there's a watermark on there. If you're sending things out to clients, like high resolution images, you can add copy protection functions in there, particularly on photos. You can link to your Ts&Cs just in your profile and say, you know, all use or all sales subject to Ts&Cs if you've got a website. And then if you're doing a lot in a particular country, just have a look about what the rules are, particularly, you know, political sensitivities, morality rules. If you're shipping something to a country, just be aware of whether it's likely to be stopped, seized at the border. You know, colleagues on the call from the Middle East will be really used to this, but if you're not from the Middle East and you're not familiar, it's worth just having a look at what the rules are. So now we will go to, I think we have 20 minutes or so for questions. I didn't want to scare everybody. I know that's a lot to take in. So I think people go back through the slides and have a look. But I think Becky and Amani, we can probably go to questions now.
Yeah, brilliant. Thank you so much, Fionnuala. That was a really interesting and informative presentation. I feel like I've learned so much. And I am not an artist, so I imagine that all the artists here, their brains are absolutely reeling. We've got a few questions coming in, which is brilliant. So I have a few questions as well, so I can always jump in, but I'll start with Yaz. Would you like me to read out your question, or would you like to read out your question yourself? I'll give you a second to unmute if that's the case. Okay, that's fine. I'll read it out for you. Yeah, no worries. So Yaz asked, what is the law regarding the appropriation of found photographs that are 50 years old in the UK and the GCC and using them in your artwork?
Oh, okay, that's a really interesting question. So I suppose if you're using photographs in your artwork, it depends how much you're using and whether it would constitute copying. So when you say the photograph is 50 years old, it's going to be when the photographer died. So if they're 50 years old and the photographer only died, 30 years ago, it would still be in copyright. So what you're looking at is you're sort of saying, okay, it's in copyright, and then you're looking at how much of it you've actually copied. So in the UK, if you were only using a small part of it and it was something like we said, okay, it's a parody, like it's clearly not a copy of the original, it's it's actually sort of taking inspiration, or it's creating a parody from the artwork, that would be okay, as long as it passes the kind of exemption test here. Now, in the GCC, they're a bit more strict on substantial use. Now, because I'm an English qualified lawyer, I do a lot of work in the GCC, but I'm not an expert in all the copyright law. And in most of the GCC countries, you don't publish court decisions, so it's a little bit harder to know exactly what's acceptable and what's not. But what you would look at to see if it's in or out of copyright is where the photographer is from, because what copyright law would apply to him, the lifetime, so it's 50 years or 70 years, and then you would look at whether it was in or outside of copyright based on when he died. So you have to do a little bit of investigation to see if it's protected or not, and that's when you then look at the substantial part. But in the GCC, it's more restrictive, or more kind of artist friendly than copier friendly. In the US, for example, you can do a lot without being caught being copied.
So Yaz is saying, but what if you don't know who the photographer is? So I imagine, you know how like sometimes you're at like a street market or something, you pick up a photograph and there's no way of tracing the photographer. What about in that case?
So if it's an orphaned work or an abandoned work, I think in some countries it's 25 years, but there are still rules around it. And that's an official orphaned work, like nobody knows who the author is. If you simply don't know because you've taken it from a street market or something like that, the position doesn't change. You can't use it just because you don't know who the author was. So it doesn't change the position at all. So it's really your risk if you do it. I mean, if you want to do lots of investigation, trying to find out who the author is and trying to find out, if there's a collecting society who look after this artist, you can, but you do run the risk that, you might actually be using a very famous image or something that the family are really, really strict about. You could end up in trouble. So I would always avoid that if it's simply that you can't find the author. Because just think about it, if, say, someone in London saw, I don't know, like a screenshot of your work that someone had printed from Instagram, they're like, oh, well, I don't know who that belongs to, I'm just going to use it. You would still want to be protected.
Okay.
Sorry if that's not what the answer.
No, I was just thinking, like, that's. But sorry, just off that, just out of interest. So when you think that if I took a photo as a non-artist and it ended up in someone's artwork just through like coincidence, like say I dropped a print of the picture, like, is it basically my prerogative to pursue legal action on that? Or is it just like, surely not everyone would worry about that, only really someone who's using their work as an artist? Or
and that usually it's your responsibility to find out and to then go and complain about it. Your rights are the same as whether you're just taking a casual photograph or whether you're a professional. That doesn't distinguish, as long as the kind of artistic quality, or well, not even quality, artistic authorship is met, so it's like unique and it's identifiable, then it doesn't matter how professional you are. But it is up to you to complain, and normally what happens is either somebody's got software installed where they can see if their images have been used, or they see it, or a friend sees it, and it's usually if somebody's commercialized it and made money, that's when you start complaining and saying you didn't have the right to do this.
Yeah,
absolutely. But yeah, it's a risk-based approach. I mean, artists, they use inspiration from everywhere all the time, and it is risk-based most of the time. Nobody would ever know, but it's a risk you take.
Okay, thank you, that's really clear. Kauthar says, is it I'm just going to read the questions actually, but feel free to interrupt me if you would prefer to read it yourself. So is it true that once an image goes on the internet, it stays on the internet forever, even after deleting? Does it float up to some mystical cloud database that only the platform has access to, or does it stay there because people may have shared or screen grabbed it?
So this is an interesting one. So if you delete it, and you can like hard delete and do all sorts of things with software to get it deleted from your account, but because you've granted a license, the social media platform could keep it. You've given them a license to use it. So even though you delete it, they will still have access to it on their database if that's what they do. And because you've given them the right to keep it, they don't have to delete it. Now, I don't know whether they periodically go through and erase things. I would say probably not. So it probably still is out there somewhere. And if other users have shared it, then it won't have been deleted. So it's very difficult for you to delete the work once you've shared it. It will be somewhere. So Google image search and other software is good because you can kind of run across the internet and see where it's been published elsewhere to try and track it, but you can't see, has it been printed and stuck on a t-shirt? So I would always assume it's still there somewhere in a magic cloud.
Okay, brilliant. Dareen says, what is the software to trace my art picture if taken elsewhere?
So I think there's Google image search is the most well-known one, but there are others. So I think if you type in Google image search or image tracing software, then there's a lot of other ones as well. You have to have a good quality image. It's difficult. So it's difficult if you've taken lots of different images of your artwork because you have to get the exact one for it to recognize it. So if you've taken 20 images of a sculpture, you're going to have to run all 20 of them to see if you're being copied. So that's another reason that, you might only want to post one or two, but have lots of others to give to clients.
Okay, great. Thank you. Alexia says, what should artists do if collectors post images of artworks they've bought from the artist on their social media?
Yeah, so some artists do ask about this because, of course, when you sell an artwork, you keep the copyright. You don't transfer the copyright. I think it depends. You can ask clients and say, if you've given them images, to say, oh, please only share low resolution images, or please credit me. And if you see them on social media, a polite like, oh, I'm so glad you like my artwork, sort of response is quite good. But I think you should be a bit careful telling clients they can't share works online, because if they've paid a lot of money for something, they take a photo and they love it and they're like, oh, look at my new artwork. If the artist comes along and says, no, you can't share this online, you're not going to get repeat orders from that customer. So it's a commercial decision. Of course, if you find that they're sharing it for commercial reasons, absolutely you can come after them and tell them that they're not allowed to do that. But use your judgment on that, because otherwise you'll be an unknown artist for the rest of your career. So it's a balance.
Okay, brilliant. Takreed is saying, what recourse does an artist have if someone took their work and sold it and they found out subsequently? My film was sold to an American distributor, and when I found out, they removed it from sales at my request. I'm UK based.
Okay, so as I said at the beginning, I can't give legal advice, and also the circumstances might change if I saw them fully. But if they've taken it down and you're satisfied with that, that might be sufficient. You could sue for damages, but in copyright claims, it's difficult to sort of assess the damages, and it usually depends on how much of your film was used. So if you had say a snippet of a film that appeared in a kind of 2-hour, then larger film or music video or something, it's difficult to say how much your film and your copyright actually contributed, because what you can do in copyright infringement is you can take part of the profits. And this happens when artists' work are used on like album covers for musicians or in music videos. You tend to say, well, you've made a lot of money from me, I want some of the profits. It's really hard to work out exactly how much you would be entitled to because it's very subjective. So even though you can pursue for damages, it's difficult to actually work out what that is, and you probably need to speak to a professional to kind of quantify the profits. The takedown is probably the most important thing. You can also ask for things like an acknowledgement, a credit, or you can charge them a license fee and say, well, if you'd approached me and asked my permission, I would have charged you this much. So you could say, well, that's how much I want. To sort of make sure that's reasonable, you sort of have to link it to what other artists of your experience would charge. But that's worth looking at as well.
Great, thank you. Mariam has asked a very interesting question. What is the case for street art and art murals? Are they copyrighted or can they be reused?
They're protected. Yeah, they're protected and they meet the test. It's difficult because, so the difference with street art is that if it's illegal, so if it's graffiti and you weren't allowed to do it, I think as everyone's seen, the Banksy that was there on the tube was gone within 24 hours. You can't complain if somebody gets rid of your work or paints over it. If you had a painting in an exhibition and somebody defaced it, then you would be protected by your moral rights. But for street art, because it's graffiti, the council, whoever owns it, can get rid of it, they can deface it, and you're not protected. So your moral rights are slightly different. But in terms of using street art in your own artworks, it's exactly the same. So there have been cases where there's absolutely gorgeous sort of street art in Shoreditch, and then car manufacturers put their car in front of a mural and they use that as their poster. You can't do that. That's definitely copyright infringement. So it's exactly the same, and the artist could sue for damages on that case. And that does happen quite a lot, because I think people think if it's out there in the public, then it's a free-for-all.
Okay, interesting. I have a question based on quite a few people were in the workshop yesterday. So it's not entirely digital art related, but one of the things that we spoke about was limited edition prints. Mm-hmm. And I was just wondering whether there's any kind of action that an artist needs to take if they're beginning to think about limited edition prints, and how to document that, or whether that's just something that there's a trust there based on the sale. Just in case I don't know whether there was a question in there, but I know it was something that we discussed yesterday.
So if you're not in control of producing the prints, like if it's a gallery?
Well, if an individual artist operating separately, say on like social media, was saying that this was part of a limited edition print, I was just wondering whether that would be something that would need to be contractually demonstrated, or whether the contract itself is by saying that it's a limited edition print.
Okay, I see. So I think if you don't say anything, if you sell a work and you don't say anything about it being a series or an edition, again, it will depend on the sort of the implied terms, but I think it would be somebody would be able to argue that they thought this was unique and authentic because nowhere did it say this is part of a series. So if you decided 5 years later that actually it was part of a series and you were doing 100 more, you could have the buyer saying, well, I wouldn't have paid that if I didn't think it was a one-off. At the same time, if you don't say anything, you can argue and say, well, I never said this was just, a one-off work. I never said I wouldn't do further editions or derivatives. So it can be argued both ways. I mean, to protect yourself, it's always worth saying it's an edition and put the number and stick to that number. So if you put limited edition 1 of 50, if you do 51, you have kind of gone against your description. So when you're thinking of how many you're going to do and you publish that, stick to it.
Okay. Do we have any? Oh, there we go. So is it possible to use, this is Mariam's question, is it possible to use media published on TV in videography work, like news?
So I think the news, let me think. So I think the news is, it's definitely protected. I'm trying to think all the different snippets. So news reporting, it works the reverse. So the news can report and have images and videos and things for the purpose of reporting, and that's like a fair use exemption. If you're using the news in your artwork, I think it is still protected, but it's not protected under the same. Do you know what? I'm going to have a look and check, because you've got the producers' rights, the directors, the presenters. So the presenter has IP rights in their likeness and their voice, almost like an actor would. And you've got the images that are used on the news that are also protected. And then you've got the producer putting the news story together. So there's lots of rights going on together, a little bit like you would have with a theatre performance or a film, that are all integrated. I will write that one down, and Marion, if you want to send me your contact details, I'll have a look and I'll come back to you on it, because I think that's a really interesting question, and normally it works the other way, where you look at artworks on the news, but actually it's really interesting. Can you use the news in your artwork?
So Tagreed is saying that she thinks that as long as you film the TV rather than use the raw archive, maybe it's fine. Do you have any response to that at all? Or?
Yeah, so there's something where, and it happens across countries. So if the kind of copyrighted work is, we call it incidental to the image, then it's okay. So if it's not a direct copy, and you're not sort of reproducing, then it's okay. But it depends on the facts whether it's incidental. So if I had an artwork or a video, and I just had, say, just the corner of my face in front of it, but most of it was the copyrighted artwork, it's not incidental. But if you're taking a photo of me in like an exhibition with different artworks in the back, that's all right. That's not copying. So it depends on the facts and what's incidental. So I think the TV, if it was in a room and the TV was there, but there were other things in the room as well, it would be incidental potentially.
Okay. Interesting. We probably have time for one last question, if anyone quickly wants to send it or shout it out. Otherwise, maybe we will consider. So Yaz is saying, what if you take a photo of a photo and manipulate it? We're getting quite Inception here now.
Very technical. So the photograph, so if you take a photo of a photo, the photograph is still protected. So we get a lot of this where the artwork is out of copyright. So like, say you have an old master, but someone's taken a photo of the painting, the photograph is protected. So the photograph still has the same copyright, even if the original subject matter is out of copyright. So if you take a photo of a photograph, the photograph is still protected under the same rights. So usually you wouldn't be using the original photograph. You would normally be using a reproduction anyway, because you probably wouldn't have access to the original.
Okay. And on that kind of matrix note, I think we've put you through your paces enough, Fionnuala.
Awesome artworks coming out of this. I'm thinking the creativity that people are planning is really
But yeah, so thank you so much, Fionnuala. That was really amazing and really useful information that I think everyone would agree is not necessarily, you don't often get the opportunity to hear directly from a lawyer about their kind of thoughts about all of these kinds of things. So thank you so much for delivering it in such an accessible and kind of easy to understand way, free from jargon. And yeah, it was just really fantastic. So this is the final workshop in our Making Marks KW digital series. So thank you everyone who's attended this workshop and any other things that we have on our program. In case you have missed anything, all of the Instagram takeovers that we did are obviously on our Instagram, and you can kind of scroll back through there to look at the works that our 4 artists from Kuwait created as part of the exchange program. Sheikha El Habshi. Oh my God, I've forgotten everyone's names. Sheikha Al Habshi, Faye Al Mansour, Stanislas, and Sarah El Gendi. So they're all fantastic. We've also recorded, this is recorded, and we've also recorded the 2 other events that we did. You can find them on our YouTube channel, and they'll also be on our website in the Making Mark section. So we'll be posting about that on our social channels, so they'll be really easy to find. If you don't already, I really recommend signing up to our newsletter, which is done through the homepage of our website, because then you can find out about all the other different workshops and things that we are doing, including our upcoming digital residency. So we'll be having new artwork made soon, which I hope that you all will enjoy. So yeah, finally, a huge thank you to the British Council, without whom this programme wouldn't have been possible, and to all the team there that we've been working with. Thank you for your support and partnership. But yeah, so thank you very much, guys, and keep in touch, and please let people know about the workshops if you thought that they were useful to yourself. Yeah, thanks.
Thank you.
Yeah.